Hello, everyone. This is Attorney Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC. And today we're doing a case update on the appeal that I filed, or the lawsuit that I filed in Macomb County against the clerk for denying my application for the CPL exemption. If you've missed the other parts of this video, this is part 3 of this case update. We have them on our blog page, radzwionlaw.com/blog. It'll be under the case update tab in the upper right corner, and check those out as well. I've linked the or I've uploaded the brief that we filed, the appellate brief or the appeal brief on the second edit all this edit. Hello, everyone. My name is Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC. And today we are doing a case update on the appeal or the lawsuit that I filed against the Macomb County clerk for denying my CPL application exemption. So this is not going to be an in-depth look at the lawsuit in general. We're just looking at the actual response that the clerk has filed to our appellate brief, or I should say our appeal brief. I have linked the other 2 posts on this topic at the bottom of this post on our blog page. All right, edit all this. Edit. Hello, everyone. This is Attorney Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC. And today we are giving you a case update on the lawsuit that I filed against the Macomb County clerk for denying my CPL exemption application. This is part 3 in this case update. If you've missed the first 2 parts, part 1 was a general overview of what happened in order for this lawsuit to take place. And then part 2 was the actual court documents that we filed. But in today's part 3, we're looking at the response the clerk has filed in response to our brief, and just some counter arguments to what they're bringing up is what I'm going to go through today. I have linked both this, the brief that they filed, the clerk has filed on our blog page if you want to read through the entire thing. We're going to look at a couple pieces of it today, but not the entire thing. I've also linked on our part 2 of this, this case update series, the brief that we initially filed. If you want to read through that, that will be on the other post, the part 2 post of I Go to Court. So let's dig right in here to what the clerk is saying. So they have requested oral arguments. Those will be set sometime here in the near future. And this is just the table of contents. So they have some cases cited here. And again, if you want to look those up or any of the court rules, you can do that. Head on over to our blog page to look those up. They're arguing, I'm not going to talk about the jurisdiction today. I just want to hit on a couple of the main points that they're making. It seems like one of their main, like their biggest thing is that besides, they're arguing that attorneys are not court officers, which is contrary to what we're arguing. The first point that they're saying is that because when I reapplied for my CPL, when I renewed my CPL back in November of 2021, that because I did not fill out the exemption portion, the portion saying that I'm an attorney and that I want to be exempt under the court officer rule, they're effectively saying now I can't go back and change my mind. I can't now apply for that exemption, which it doesn't really make sense. And I guess, the example that I would say is that if you had a driver's license in Michigan, a standard driver's license, and you went, maybe you had it for a couple of years, and then you went and took your motorcycle endorsement class to become certified to then apply with the state of Michigan to get your CY endorsement so you can ride a motorcycle on the public roads. Let's say that you took that class, you had your certification, you held on to it for a little bit, and then you renewed your driver's license, but you didn't say anything about your endorsement, aspect of it. And then maybe a couple months go by and you think, yeah, you know what, I'm gonna apply for this now. I'm gonna turn in the correct paperwork, and then you do so, and the Secretary of State says, well, you didn't submit it back when you should have, when you renewed your license a couple months back, even though you were certified. You should have done it then. So now, because you're doing it now, we're going to deny you. That's effectively what the clerk is arguing with the CPL exemption. It's, before, I get a CPL before I was an attorney, and then I'm renewing it every time I need to. And then all of a sudden I learn about this law that I may be exempt from the pistol-free zones or the concealed carry-free zones. And now, because I've already submitted multiple renewals in the past, I'm now barred or precluded from submitting an application in the future. That doesn't make any sense. Just because you don't know about something and then you find out about it and you try to apply for it shouldn't prevent you from doing it because your past actions, you didn't know about something. Okay. So that's kind of, it's a very, overview of that, but that would be a response that I think I would give here. Is just that something that you do in the past doesn't preclude you from doing something in the future. If you learn about that and you're qualified to apply for that, that's not typically how the law works. The other big point that the clerk here is trying to make is that I'm not a court officer, and they go into, kind of legal mumbo jumbo about cases and how the legislature interprets terms and everything. But the meat of this point here is that everyone needs to understand that when a legislature writes words on a piece of paper to be submitted and voted on to become law, right? They write the bill and then it becomes the law. They don't put words into something that that shouldn't be given any weight. Okay, so the legislator doesn't just write words just for fun that shouldn't be given weight. The court has recognized this, that if a legislature writes a word, it's supposed to bear weight, or it's supposed to have meaning. It shouldn't be superfluous, or it shouldn't be just read over without given any due authority or respect to that word. Okay, so but the clerk here is citing this kind of concept of, well, if the court wanted to define or carve out a section for attorneys, they would have done so. But then the court cites to, instead of citing to a statute or a law that the legislature has used, or even a case, they cite to Michigan court rules that the Michigan court rules aren't even defining what a court officer means. It's pretty much laying out the process in which how a court officer becomes appointed or is employed by the court. So it's not an apples to apples comparison there. I think that will be something we'll have to bring up on oral argument. And the other thing here that ties in with this is that the judge, they bring up that there's a section in the statute that allows for judges. I think it's, let's see here. Oh, right here. So the legislature clearly intended to limit the number of people that are exempt from carrying a concealed weapon on the specified premises. If the legislature intended to be exempt, or intended to exempt all attorneys, it simply could have said so. Yes, that's true. However, they go on to say that the fact that the exempted judges clearly indicate they did not exempt to include attorneys as judges are attorneys. So this would be my however comment here. Judges are specifically listed, but that doesn't mean that attorneys could not be included under a general term of court officer, because number one, court officer is not defined, but number two, the legislature doesn't, you can't tell me the legislature doesn't ever make generalized statements that encompasses more than one specific party. Okay, so just because they carved out a section for judges doesn't mean that a broader section of the law that defines other aspects or includes other things, multiple things in that term, that we can't interpret it that way, or that we shouldn't read the word court officer or any generic term as, well, it's generic, so that excludes attorneys because judges were listed over here and they could have done this. That's not a logical argument. Okay. The other thing is that the point that they're making here, and they do kind of a poor job about it, they actually cited the wrong court rule. And I'll read you what the right court rule is here in a second. We'll look at that and how it doesn't apply. But it's they're talking about how the Michigan statute requires an individual who's applying for this exemption to submit proof of employment. And number one, I did that. But number two, okay, it's right here. They talk about the state statute's requirement is just proof of employment. It doesn't go into anything in crazy detail. All right. But the clerk then cites, they explain this, right? They say that, let's see, which is defined, a court officer's employment. So right here, MCL 28425B13 provides that a clerk shall indicate the MCL exemption on the CPL if the applicant provides acceptable proof, which is defined in MCL 28425B 22A, and then the subsection here as, what is that? Subsection 12, as a court officer's employee identification card. Okay, that's the term, right? It's an employment identification card. All right. But then they go on to say that, number one, I don't have one issued pursuant to MCR 3.105 F1. All right. So number one, that's not the requirement. The requirement is defined in 28425B 22A subsection 12. And then they go on to say, number one, I don't have one. And number two, it doesn't comply with MCR 3.105 F1. All right. Now, I don't know if this was just an oversight on their part, but this section here, this MCR 3105 F1, this is what this says. It says seizure. A copy of an order issued under subrule E4 must be delivered to the sheriff or court officer, who must, number one, seize the property described in the order. That has nothing to do with submitting an employment application card for proof of employment. So that must have been just an error. They must be citing the wrong code there. I'll give them the benefit of the doubt on that one, but it's just funny that they're trying to use a court rule to elaborate upon something that's listed clearly in the statute, this MCL 28425B statute, as far as what the actual requirement is for the employment. So those are my thoughts, big picture items there. I think those are the two big ones that they're harping on. And again, if you want to read this, we will link it in the blog post on our page. It's not very long. I think, yep. So there are exhibits. It's less than 7 pages. It's about 5 pages total reading, 5 or 6 pages total reading by the time you're done with everything. And then they talk about the court not having jurisdiction and everything else. It's interesting, but I think that'll have to be hashed out first when we get in front of the judge, because I think they're treating this like an appeal, but really it's a claim of appeal that was submitted based on the denial. We use the form that the county provides or the state provides, and we submitted it within the 21-day window for an appeal for a denied CPL. So those will be kind of some splitting hair issues. I don't know what to think about that yet. I think it shouldn't be an issue, because the argument that I will make is, well, Judge, if we dismiss this today, we'll just reset it up. The clerk's going to deny it again, and then we'll make sure that all the timing is met if this is going to be dismissed on. I think the clerk says here that it took 119 days for us to submit the brief, but we submitted the appeal within that 21-day window. Yeah, right here, 119 days. This is on page 1. You can read that. But so anyways, I hope this video finds you well. If you have any comments, please leave them below. I'd like to hear what people think about this kind of stuff. And maybe take a look at the brief first and then ask some questions or make some comments that would be helpful. Might help me think about some arguments to make here coming up the next month here when the appeal process or the oral argument is scheduled. So, all right, thanks everyone. Please consider comment, share, like, subscribe, all that good stuff. And we will see you next time. Thanks again for watching.